As I have already told you that public interest litigation is a recent concept, and R.B. Mishra, Justice R.B. Mishra of the Supreme Court of India in the year 1986 observed that Supreme Court, not Supreme Court, he is a judge of the Supreme Court. He observed that public interest litigation is comparatively a recent concept of litigation, but it occupies an important status in the new regime of public law in different legal systems. He says that, I repeat again, that it is a recent concept which has developed in the field of legal system, and it is comparatively a recent system, a recent concept, and it occupies a very important position or status in the new regime of public law in different legal systems. So Justice R.B. Mishra of the Supreme Court observed that the Supreme Court, in a case, the name of the case is Dr. Upendra Bakshi and others. Supreme Court observed that the public interest litigation is not a litigation of an adversary character undertaken for the purpose of holding the state government or its officers for making reparation. This kind of litigation involves a corroborative and cooperative effort on the part of the state government and its officers. The lawyers appearing in the case at the bench for the purpose of making human rights meaningful for the weaker sections of the community. It marks a step forward in the direction of reaching socio-economic justice to the deprived and vulnerable sections of humanity in this country. As you know that India is a welfare state, but the poor section of the people and the vulnerable section of the people may not be able to take legal access for restoration of their legal rights if their rights are violated. So, there is a provision for legal aid which we have already discussed, and for the weaker sections of the population, public interest litigation may be initiated in a court of law by any person to for the restoration of some rights and liabilities of a particular class of community or a part of the community if their rights are violated, if the city where citizens enjoy the rights given by a state government, a local government, or a national government. So, we have already discussed about the writ petition that may be filed in the High Court. We have already discussed about the writ petition that can be filed in the Supreme Court, and Article 32 says about the about seeking judicial redress for the legal wrong or injury caused by anybody, to person or determinate class of persons. So these are very important, and I think by now your concept of public interest litigation is very clear, and through WhatsApp group possibly I might give you a note in the next week, and we'll discuss also if needed. And now we plan to discuss another important point, that a person can invoke inherent jurisdiction in a criminal matter or public also may initiate or invoke inherent jurisdiction in a criminal matter who is not personally aggrieved. Actually, there is no such thing as public interest litigation in criminal law. Any person in whose presence some cognizable offences is committed or is about to be committed is obliged to inform the police or the magistrate on duty for taking proper and appropriate action in that matter. I want to explain it to you. If any person or a group of people find that an offense or a crime is committed, then some cognizable crime is committed, then it is the duty of that citizen or the group of citizens to inform the police or the magistrate so that proper action is taken in that matter. As a matter of fact, it is the responsibility of the state to protect the people from being offended by crimes and take action against the offenders or criminals. Do you get the point? That the state government should interfere immediately to stop such, interfere immediately from happening such crimes, so that peace is restored in the community, in the place. The state represents the people and is obliged to protect the interest of the people against crimes being committed or punish those who have committed crimes so that others apt to commit crimes may be deterred out of fear of punishment. Is it clear to you that the state is in an obligation to stop from happening such offences, and they should take immediate action against those criminals or offenders so that the actions of the police or actions of the magistrate or actions of the administration may deter other people from committing such crimes. There is no requirement in the Code of Criminal Procedure that aggrieved or offended person himself only is obliged to take action against the offender or criminal. Now it is very clear that the state government is responsible for restoring peace in the community, and PIL may not be the weapon, but he can invoke the jurisdiction in a criminal matter as a member of the public who is not personally aggrieved if he or she sees that some crimes are going to happen.